Hey everyone, it's attorney Matthew Ligon Sanchez here. Today let's talk about establishing and revoking kinship guardianship in Albuquerque, New Mexico. Are you looking to establish guardianship over a child in your care? If so, first you're going to have to be 21 and the child's going to need to be living with you. If you're 21 and the child's living with you, there are two ways to easily get guardianship. One, the parents agree to guardianship. Two, parental rights have been terminated or suspended. Now, if the parents contest guardianship, if they say, no, we don't agree to guardianship, then you're gonna have to show that the child has lived with you for 90 consecutive days and that the parents are unable or unwilling to properly care for the child, or there's extraordinary circumstances. Extraordinary circumstance, something major. Maybe the child hasn't lived with you for 90 days consecutively, but the parent is a complete mess, can't take care of the child, CYFD's been involved, something really, really bad. If you can show something really bad, extraordinary circumstances, then the court can grant you guardianship. Are the parents consenting to guardianship? If so, you get that consent in writing, you file it with the court, and the court's gonna grant you guardianship. The court, they don't wanna get their hands in the mix if the parents agree. If the parents agree to guardianship, they're fine with it. They'll sign off on the order, you're good to go. Now, things get a little bit messy when the parents don't agree. When they contest guardianship, you're gonna have an initial hearing, you're gonna show up at that hearing, the parent is gonna contest, they're gonna say, no, I don't agree to guardianship, I don't agree to guardianship because I'm able and I'm willing to take care of my child. And in that circumstance, if you can show the requirements, if you can show child's been with you for 90 consecutive days, parent is unfit to care for the child, or there's extraordinary circumstances, if you can show those things by clear and convincing evidence, then the court is going to grant temporary guardianship. It's valid for 180 days, and then they're going to get a guardian ad litem involved. And the guardian ad litem, GAL, is going to interview the child, is going to do an investigation, maybe do a home review, talk to collateral sources such as therapists or counselors, basically just get to the bottom of everything, and then they're going to come back to court and they're going to make a recommendation. They're going to recommend either yes, guardianship is going to take place, or no, guardianship is not going to happen. And your judge is going to be heavily influenced by that JL's recommendation. So whatever the JL says, most likely that's what your judge is going to do. If the JL says yes to guardianship, your judge is probably going to say yes to guardianship as well. Has kinship guardianship been granted, but you want to revoke it? If so, you're going to need to file a motion to revoke guardianship. Guardianship is temporary in nature. It doesn't permanently terminate your parental rights, but it can go on forever until you file that motion to revoke. So if the guardians have guardianship and you're a parent and you want to stop the guardianship, if you don't file that motion, guardianship is just going to keep going forever until you finally file that motion. So you're going to need to file a motion. You're going to need to show that there's been a big change in circumstance. A material change in circumstance is a legal term. You show that there's a material change in circumstance. You show that the child is best served by being with you, that you're capable of caring for your child, and you propose a transition plan of how the child is going to be transitioned from the guardian's home to your home. And then the judge at that point can consider the facts and they can revoke guardianship. But if you don't file that motion, it's going to go on. Just like getting the guardianship established, there's probably going to be a JL appointed. JL is going to do an investigation, and then there's going to be a hearing set. They're going to come back. The JL is going to recommend either guardianship be revoked or guardianship stays in place. Judge is going to be heavily influenced by the JL's recommendation. At times, the guardian will contest revoking guardianship. They'll say no. The parent not able or willing to care for the child yet. Maybe they're contesting it and they're saying because there's drug use, there's criminal activity in the home, CYFD is substantiated abuse or neglect, anything, criminal activity, unsafe home, whatever their reason is, they could be saying, nope, I don't want to get rid of guardianship. we can't revoke guardianship yet. Court needs to hear these facts. Court needs to know what's going on and make a determination based on the best interest of the child. Now, when this happens, usually the court is going to get a guardian ad litem involved to do an investigation, and there'll be a final hearing. That final hearing, the guardian ad litem will testify, and the court will decide whether or not the guardianship will be revoked. At times, revoking guardianship, it can take a long time. It can take a long time to find out that you need to file the motion, get into court, possibly have the guardian show up and contest guardianship. Maybe they're saying there's something going on with CYFD. Maybe they're claiming there's drug use and we need a drug test. We need a 6-month hair follicle test. For any number of reasons, the process can take a while. It can take a while to play out. So if the guardians are contesting the revocation, you should anticipate a drawn out process. Unfortunately, this isn't something where you file the motion and then a button is pushed and it's revoked. It can be a long and drawn out process. There can be several hearings. There can be a guardian ad litem. There can be possibly therapists that need to speak with the guardian ad litem, the child, family members. So unfortunately, it's not a quick process, and at times it can become stretched out. Getting guardianship or revoking guardianship, it can be an emotional process. It can be highly emotionally charged. You're gonna have a hearing, you're gonna have a parent that shows up potentially, and they contest guardianship. You should expect some tears at that hearing. You should expect the parent explaining to the judge, wailing to the judge potentially that this is unfair, you're taking my child away, I can care for my child. It can be highly emotional. And now at the other end of the spectrum, when guardians, they have a significant relationship with the child, maybe they've raised the child, they've been there from day one potentially, or they've just been with the child for years and years, and a parent comes back into the picture and says, I want my parental rights restored. At times, it's really hard to let go of that. It's hard to let go of a child that you've developed a significant relationship with. So from both ends of the spectrum, it can be a very emotionally charged time. Do you still have questions about getting or revoking guardianship? If so, call me. Call attorney Matthew Ligon Sanchez, call 505 Sanchez. I'll talk to you about your case. We'll get to the bottom of the facts and we'll discuss your guardianship case. Call me attorney Matthew Ligon Sanchez.